Now, we will refer a little bit more in depth to the Inter-American Commission on Human Rights. As we said, this body belongs to the OAS, so it will be located at the main headquarters of this organization in Washington, D.C. This body operates in 5 different ways. First, it elaborates reports, different kinds of reports, either referred to a specific right, for example, a report on the fulfillment of due process in the Americas. It also writes reports on countries, where it may refer to the protection of different rights, let's say in Honduras. It also produces its annual report, where it refers to some states where there is a delicate human rights situation at the time. A second way in which the Commission operates is by granting hearings, where states, NGOs, or individuals bring into the attention of the Commission some reality that may concern them. Generally, there are many people who request being heard, so it is not easy to be granted a hearing, especially if you want the Commission to hear about an issue that is not within its priorities. That would happen even if the theme is very relevant. This is something that I said because it happened to me. I thought that a theme was extremely relevant, but the Commission didn't think so. Well, however, if an NGO manages to be granted a hearing, this could be an efficient way to place an issue in the public debate, because these hearings are recorded and uploaded to the internet. A third way in which the Commission operates is by its on-site visits to states, where it assesses the human rights problems of a particular state. These kind of visits are very exceptional, not only because they require a substantive expenditure, but also because they require the state's acceptance of this visit. And many states simply refuse being visited, especially if they are willingly violating human rights. Fourth, and probably the most renowned or well-known way in which the Commission operates, is through the individual petition system. This is a mechanism where individuals, communities, or states claim that a state has violated one of the rights enshrined in the American Declaration on the Rights and Duties of Man, in the American Convention on Human Rights, or in some other treaty establishing the possibility of using this petition system. It is important to note that individuals may bring claims against any member state of the OAS, regardless of whether it ratified the American Convention on Human Rights. However, there is a difference on the outcome of these petitions, depending on whether the state ratified or not the American Convention. If the state has not ratified this convention, the American Commission may only analyze violations of the American Declaration on the Rights and Duties of Man, and the outcome of this petition will not be a binding decision. At the most, it will be a recommendation to the state, a statement that seeks to name and shame the state. By contrast, if the state has ratified the convention, the individual may claim either a violation of the declaration or the convention. Additionally, the outcome may be a report that is submitted to the American Court of Human Rights, which will probably end up with a judgment that is binding on the state. Finally, a fifth way in which the Commission operates is through a system that grants precautionary measures in cases of serious and urgent situations presenting a risk of irreparable harm to persons or to the subject matter of a pending petition or case before the organs of the Inter-American system. The Commission grants only a small number of these measures. For instance, in 2020 it granted 58, even though that same year there were more than 1,000 requests for precautionary measures. The Commission mostly grants these measures when there is a very serious situation, such as a risk to the life of an individual. These precautionary measures are not binding in nature, which means that the state may act against them, and it will not incur on international responsibility when doing so. In other words, the Commission operates, again, based on the system of name and shame. However, this political effect may be very compelling for the states. Anyway, if the state is party to the American Convention on Human Rights, the Commission may request the court to issue a binding interim measure on this urgent matter. This is all we think is necessary to know about the Inter-American Commission. So, we spoke about the Commission, now we'll refer to the court. Well, we'll say a few things about the Inter-American Court of Human Rights. This court is located in Costa Rica, has 7 judges. These judges do not reside in Costa Rica. They only have several sessions per year. Nevertheless, even though the judges don't sit permanently on the court, there is a permanent secretariat composed by a significant number of lawyers that work all year round at the court. The Inter-American Court has two main functions, the advisory and the contentious jurisdiction. According to its advisory jurisdiction, the court interprets an international human rights norm applicable in the Americas or defines whether a domestic statute is compatible with international human rights norms. In principle, these opinions of the court are not binding on states, but the court created the doctrine of conventionality control, of which we will talk by the end of this class, according to which states parties to the American Convention on Human Rights should follow the interpretations rendered by the court in different cases and opinions. This doctrine is very much debated. We'll talk about it at the end of the course. Going back to advisory opinions, they are important because they may influence states' behavior, but they can only be requested by states of the OAS or bodies of this organization in areas in which they have competence. Nevertheless, it has happened that members of a private organization have convinced a state to request an advisory opinion. As we said, the second function of the court is to decide on contentious cases. This means that the court will issue a judgment in a case followed against a state that is accused of violating the human rights of an individual. Both individuals and states may lodge a claim against the state, but the court has never analyzed a claim between states. Only the Commission has received cases where a state complains against another, but political concerns make it very difficult for states to bring cases against each other. The contentious jurisdiction is the function of the court that is most widely known, so now we will refer in detail to the procedure of individual petitions, both before the Commission and the court.